rise. Yes.
Application in the matter of FHR.
Mr. Siblett, could we begin by an introduction to everybody in court, please?
Yes. Thank you, my lord. Well, my lord, I appear for the applicants with my learned friend Mr. Liu as my junior. My learned friend Ms. Mulholland appears for the First Respondent Trust, and Ms. Holleran appears for the Guardian.
Yes.
Next to me is my solicitor, Mr. Da Silva,
who's been working very hard. Thank you very much for all that you've done to get this case ready for this hearing.
And at the back are my clients, Mr. and Mrs. F, and I...
Well, we'll come on to that in a minute.
We'll come on to that in a moment. And next to them, they're Rabbi Goldberg.
Would you forgive me? Can I just be the rabbi on the right?
Yes.
Thank you very much.
At the back, of course, is the solicitor for the Guardian, and I think we have a rep for the trust.
Thank you very much.
I'm afraid I don't know their names.
Don't worry. Thank you very much. Next, can we just be clear about the anonymity position? Can I remind myself of the order?
It's Supplementary Bundle 2, page 2, page 1, tab 2. I've got it open.
So I've left mine in my room. I'm just going to ask Miss Milady if I can just have a look at hers.
I think it's Supplementary Bundle 1.
Yeah, sorry, it's Supplementary...
Page?
Supplementary... No, it is Supplementary Bundle 2, page 1.
Right. There we go.
And the meat of it is at paragraph 3 on page 2.
So what is the restrictions are on the forenames of the parents, the forename of the child's sibling, and their address and other matters I see mentioned there, and the clinicians. I was aware of because of the judgment, the clinicians' names are in the revised. All right. The child's name is in the public domain.
Yes, Alta.
And the child's the family's surname is in the public domain. The family's surname is in the public domain.
Yes.
Thank you very much.
Thank you.
Thank you very much.
No, thank you, my lord.
The next thing I just want to say is this, if I may, Mr. Simmons. I want to begin by addressing the parents. I understand that the mother speaks English, some English, and the father does not. Is that broadly speaking?
It's the other
way around. Forgive me. I just want to say this, if I may. We're going to be dealing with a legal argument and matters of law, but none of us will forget for a moment what this case is about. It's about your child and the suffering and the pain that you are going through and have been going through since she was born is something for which we all have the deepest sympathy and the strongest feeling. And we won't forget that for a single moment, I promise. I want to say as well, Mr. Sibbett, if at any point you or your clients would appreciate a break in the course of the hearing, because I can imagine we're going to be talking about very difficult matters, then please let us know and we'll try and accommodate that if we can.
Yes, thank you very much, my lord. And can I begin, in fact, for thanking the court for convening quickly and in person on this matter. And it may have been of some surprise to people reading about this case that the original hearing was in fact conducted over the video platform, which can make some of the issues harder to present and put across to the judge.
Well, I think all of us, I speak for all three of us, that we're all finding it much better to be back in court. For reasons it's quite hard to explain, Mr. Siblett, but the dynamic of the hearings work much better.
Exactly.
In this sort of case.
And the implications of the decision taken of course, extremely grave, resulting in the withdrawal of life-sustaining treatment from a 2-year-old girl, and the solemnity and significance of this exercise being conducted in person for the reasons that my lord has identified.
Having said that, I have no reason to doubt that the proceedings suffered in any way because of the way in which they were
I was also going to make that observation. We don't complain about
No.
that, as you will have seen in the grounds. But I do want to thank as my Lord has thanked those instructing me for the amount of work that's been done. It's quite clear that the court had to organise itself, convene very quickly, and
Well, we knew that we
appreciate
anticipated this appeal would come, and we took steps to make sure it came before the court straight away. And of course, this is an application for permission to appeal. At
Yes.
the moment, the practice in this court is to list such applications in this type of case involving end-of-life decisions about children for a hearing in court. That's the current practice,
Thank you.
which is why we're here. But it is first and foremost an application for permission to appeal.
Thank you. Now, as has already been observed, there is, of course, a video link, and there is a lot of
Yeah.
interest
Yes.
in this case. We've already touched on what is in the names in the RRO, but I would be grateful if the
I've got
court
it now.
would look carefully in the publishing restrictions in relation to item 3, paragraph 4
Yes.
as well.
Yes.
And that's a matter that is both relevant to the way the discussions take place in court and the submissions made in court, and also to any judgment.
Yes, of course.
Thank you.
Can I just make another observation? There's some. I know that your clients have not been able to see Alta as much as they would have liked. I've seen what is said about that in the evidence. We all have. And for my part, at least, I wanted to be clear that there's absolutely not a shred of criticism for the fact that they've not been able to see her. And if there was any suggestion of criticism, it's not one which I would endorse for a moment.
Well, I'm grateful, my lord, and in fact, I was going to address you on two aspects of that. First, as you may have seen, the position was they were in fact attending very regularly until
Yes.
COVID struck, and
Yeah.
indeed, Alta's father learnt to drive so that he could
I
sort
saw
of go to and
I've
from
read.
the
It's
hospital
the
and
father.
so on.
It's what Mr. F said in his statement that I particularly looked at on that point.
And also, and this is again a point I should be moving on to on the substantive points, one of the features of their culture and religious practice is that they look for guidance and instruction and stuff, and they have taken immense efforts to find out what they should do, which goes wider than the physical presence alongside Alta. But they certainly have been present when able to, and for and including the reasons that we just touched upon, it has been painful to them not to be able to go and spend as much time with her as they
Well,
would.
I expect in that respect they share an experience of other parents
Absolutely.
in the last 15 months,
Absolutely.
and other relatives too. Yes.
Well, my lord, can I then move to what it is we want, and highlight some of the points that have already been made in the skeleton but need to be amplified and explained orally.
Can I just say before you go, maybe you were coming to this first, perhaps to deal with the fresh evidence that you want to adduce.
Well, I wanted, if I could, just to headline what it was we want and then come to that, if I might. But obviously that is high up the agenda. What we say is that you can grant permission to appeal and reverse the decision made by Mr. Justice MacDonald in relation to the declaration as best interests, and include the fact, if necessary, that it would be lawful for Alta to be taken to Israel. If you're not with us on our primary point, then it may be appropriate to remit the case, having ordered that such new material as is appropriate is admitted, and possibly augmented by yet further material that the material identified might lead to. Or, if you're concerned about the cogency of the existing fresh medical evidence, knowing that there's been effectively a very short period of time within which to obtain it, and this being a case with very, very many pages of medical notes, it may be, but we don't urge this at all as our primary position, that you would want to adjourn this hearing for further consideration. The next point to make at the outset, and this informs some of the fresh evidence that we wish to admit, is that this is a case with very distinct characteristics. This is not one of those cases in which the parents are just, as it were, hoping for something to turn up medically to see if it makes a difference. This is a case, we say, located entirely within the importance of this child's and this family's race, religion, and culture. And the decision in this case, we say, should be in accordance with Alta's and her family's religion, not in spite of it. And leading on from that, although, and you may have seen this in the evidence, although Mr. F is also a US citizen, and indeed there are some interventions in the fresh evidence made by various people in the US Congress and so on about this specific case, we don't say that that additional US citizenship is one of the things that is important on this appeal. This is an appeal about Alta's religious identity and the respect that that is entitled to in the decision that should be made in her case. And essentially, we say that the judge below made the wrong findings in relation to the role that religion played in Alta's life and best interests. He made wrong findings in relation to the implications of the evidence that he heard about pain. And the subset of that is that there is new evidence that the applicants would like to admit, which casts a doubt on the pain evidence and also informs the court to a greater extent than was the case before Mr. Justice MacDonald as to what the religious position is and what the position is in relation to Israeli law. And the court may well have noticed that Mr. Justice MacDonald observed that he had very limited evidence about what the position would be in Israel, both as to the practicability of transfer there and what would happen to Alta when she went there. And we say that this is material that can and should be admitted into these proceedings because it was a deficit in the proceedings below. It should also be pointed out, my lord, and I think I'll come to the application now to adduce the fresh evidence. It should also be pointed out that although the directions were made at the end of January and the position unfolded thereafter, it would not be right to think that the parents were, at the end of January of this year, in possession of all of the medical evidence and able to take informed decisions about what additional evidence may be required. In fact, the position is much less satisfactory. The disclosure of medical records did not all occur at once. Documents came about in sequence, and these are instructions late instructions we received yesterday. But as we understand the position, having checked it with some of the correspondence between their former solicitors and their rabbi, that there were 1,600 pages of medical records on the 18th of February 2021, an additional 4,000 on the 9th of March
What
2020.
was the date in February? 18th of February.
18th.
Thank you.
4,000 more on the 9th of March. On the 6th of April, there didn't appear to be any minutes of the multidisciplinary team meetings, and the sort of final tranches of medical evidence were not supplied until the 27th of April 2021. And my lords, if you look at the position statement on behalf of the applicants in this case, the fixers, made in the court below, which is to be found in at page A40 of bundle 1.
Supplemental bundle 1.
Supplemental bundle 1.
Yes, mine starts at A37.
My lady, I'm sorry. I'm sorry.
Mine starts at A37.
Oh yes, thank you. Yes, the position statement begins at A37, but at page A40, paragraph 9,
I see, yes.
you see that complaint was being made about the absence of at least NDT records, and it being suggested that further efforts will be made to obtain the full records prior to the hearing. Well, this document is dated the 17th of May.
But the substantial bulk of the medical records were available by the 9th of March. Yeah.
Yes, and in fairness to the points that are taken against me, and dealing with some of those full on at this point, the directions set by Mr. Justice MacDonald did not at that stage include a request for a neurologist. However,
Request from who?
from the fixers.
Right. So in January, you didn't ask your predecessors did not ask for a
Yes.
neurologist.
But what we say about that is that the position in relation to what turned out to be, for Mr. Justice MacDonald, a crucial and we would submit decisive issue, which is that of whether Alta suffers pain, and if she does, the extent and consistency of it. That was much more equivocal at that stage. So while I'm of course mindful of the reluctance to allow people, as it were, to reopen issues that could have been dealt with or should have been dealt with previously, this is a case in which there was a degree of evolution and a degree to which it wasn't entirely clear to what extent the evidence in relation to Alta's neurological functioning was in the way that it came across to Mr. Justice MacDonald. Now, we say further, of course, that even on the evidence that he heard, he went too far in his findings, and I will address that point in a moment. But dealing, therefore, with...
Can I just remind myself of the directions order?
Yes, that's in supplementary bundle 1 at page...
B18?
It's early on, yes. It's the order of 29th of January.
Yes.
B18.
B18.
That is
yes.
B18,
B18,
isn't it?
yes.
Right. So at that hearing, the experienced leading counsel, I assume, who appeared throughout for your clients, was instructed,
Yes.
attended that hearing.
She was, and there was a position statement. There was a position statement, but yes, all of that's right. Oh, sorry, not with the junior. I'm grateful to Ms. Moore.
But and right.
The order was made in those terms. You will see that the paragraph 4B19. there was an order that there be disclosure of her medical records. Brackets, we would
Yes.
imply, means all of them.
How had the three doctors, paragraph 6, been instructed?
Well, that's an interesting point. Ms. Mulholland says that Dr. H, although I don't think he's covered by the anonymity order, but Dr. H.
Well, the first and third doctors are not covered by the
Yes, that's
order,
correct.
but the second one is. Is
Yes.
that right? He's Dr. B.
B.
He is Dr. B. He's
So
a
we
treating
can-
clinician.
So Dr. Hart and Dr. Samuels, there's no need to keep their names.
Thank you.
It's easier, but the second doctor is Dr. B. So yes.
So,
Yes.
well, Dr. A
Yes.
and Dr. B had supplied their factual clinical evidence as part of, along with the application. They had obtained a second opinion from Dr. Hart. And so while Ms. Mulholland is technically correct to say that the further report from Dr. Hart was put in Part 35 form, it is not actually, in my submission, a case where this was truly an independent expert, because he was an expert who had been brought in by the hospital in order to provide a second opinion. And as you will see, my lords, when we look at some of the things he was saying, much of what he was saying and doing was seeking to explain the hospital, or the position, to my client's parents. A lot of his presence for the physical examination that he conducted of Alta.
And was Dr. Samuels in the same position, instructed before the proceedings got underway?
Yes. So although we see reference in the order to putting questions, and at a subsequent point they're described as, well, at a previous point they're described as Part 35 questions, because my predecessor counsel has suggested that as one way of dealing with this. These were not Part 35 experts as such. Now, I don't know to what extent that is a point that needs very significant amplification, but in the bundle of authorities...
Is it Part 35 or Part 25? Which rules are we in?
25.
Oh, 25, sorry.
Yes.
It's found, yes, sorry.
Part 25. All right.
But the same sort of structure.
Yes. But there's no... Is it your case that the independence of their opinion is undermined as a result of the way in which they were involved?
It's my case that it would be wrong to say that, in a sense, these people should be treated as entirely independent, chosen experts, because this comes back to to what extent did the family have an opportunity to get truly independent external evidence?
This point must have been uppermost in the minds of all those who appeared at the hearing on the 29th of January.
Yes, and
Because it's the first question anybody would ask in those circumstances, representing the parties. Do we need to get, what further expert evidence do we need to get?
well, in that same bundle, my lord, at page A8, we see part of, well, it begins at A6, but page A8, paragraph 6 is where I would like you to look. You will see that my predecessor, and this is dated 28th of January, had asked questions to Dr. B, Dr. Samuel, and Dr. A. Otherwise, permission is sought to instruct an independent paediatric neurologist. So the idea that an independent paediatric neurologist may need to be instructed...
Yes,
and
you've missed a bit out, unintentionally.
Yes, it is unintentional.
Provided that the questions are answered by each doctor individually,
Yes.
independently. In other words, on that condition, the parents' representatives were satisfied that it would not be necessary to get a further expert.
I think that has to be right, my lord. I can't
that's,
make
and that's
submissions.
unsurprising,
Yes.
because,
Well,
well...
I'd say it is surprising.
You say it is surprising.
Yeah, I'd say it is surprising, and that had those instructing me been involved for, it may very well be that very different decisions about that would have been taken, and it would have been the last sentence that would have been argued for. Now, as it happens, the questions were also put to Dr. Hart, who is not included in the list of people there.
Yeah.
But as you will have seen in his second report, he addresses the questions that he's been asked. So, for whatever reason, and my Lord says this is something that would have been uppermost in anyone's mind, for what was being suggested as the secondary position in this case might in many other cases have been in fact the primary position. We say it's a fundamental issue, but more importantly, and so as to introduce a degree of how people actually think and work, at that stage, the medical records were not available. So to the extent to which anybody could make a fully informed decision as to what medical evidence was going to be necessary, plus, we say, and a different looking landscape as to what was being said about ALTA's functioning and so on, meant that the position that we would say ALTA should be in, or rather ALTA's parents should be in terms of knowing what the evidence is, did not unfold in the way that we say it might and should have done.
Well, nonetheless, there was a paediatric neurologist instructed to do the expert.
Yes, yes, of course that's right. And you see, my Lord, if I can turn to the notes which I sent yesterday, and I hope my Lord and my ladies have had an opportunity.
Speaking note.
No, the applicant's note in support of the application to reduce fresh evidence.
Yes, that's right, yes.
Yes.
I'm calling it a speaking note, but in fact it's, as you say, it's your note on that point.
I have something else I've called speaking note, which I might not want
Okay, all right.
to see at this stage.
Okay.
But yes, that note, you will see that I have not made any positive submissions, to call it that, on paragraph 11 on limb 1 of the Ladden-Marshall test. However, I do say that I want to modify that slightly, that actually because the evidence came about or unfolded in the way that I've told the court and came about later than might have been expected, that does have a bearing on the extent to which under Ladd and Marshall it can be said that the evidence could have been obtained at the time. But the other point, of course, to make, and I've set this out in my notes so as to save the court's time rather than to extend it, is that, of course, you are not formally bound by Ladd and Marshall. The test that you need to apply is the one that I've set out in paragraph 9 of my note. There's a prohibition on receiving evidence which was not before the lower court unless you order otherwise. So you've got a very broad discretion. And while Ladd and Marshall is still routinely referred to 70 years after it was decided, there are plenty of situations in which courts, including the Court of Appeal, have decided that it should not be slavishly followed. And indeed, I've put at paragraph 22 a reference to the case of Singh and Habib, which is in our authorities bundle at tab 16, where in a case where there were concerns about a fraudulent road traffic claim. New evidence emerged essentially after it had all been fought out in court and so on, that there was something very untoward going on here, and the insurance company tried to reopen it and adduce fresh evidence. And in that case, and I will ask the court to turn to it if I might actually, because it does make the point quite succinctly. Authorities, tab 16.
Which bundle of the authorities? 1 or 2? 2, thank you.
Oh, I double-sided mine, so yes. Tab 16. This is
Public interest, paragraph 14. Is that your point?
yeah. Well, it's. Well, I'd like you to look at paragraph 9, if I might, at the bottom of page 4, because on the face of it, that gives the court a wide discretion, but it's still Ladder Marshall has a strong influence on the way in which the court should proceed. And my particular point is, as my lady has identified at paragraph 14, they are important, but in these matters they are not to be taken as a straitjacket. Public interest, to say nothing else, satisfies me this new evidence should be admitted. Don't need to read the entirety of the paragraph, but what was regarded at the end of paragraph 17 as a deeply disturbing case which the public interest requires should be re-investigated on a new trial with the evidence admitted. So we say that if reopening what might be a fraudulent insurance claim, if it justifies if there is a sufficient public interest in a what appears to be a fraudulent insurance claim to reopen that and to allow fresh evidence, then what could be a greater public interest than ensuring that the courts make the right decision in relation to literally the life and death of a seriously
Yes, but
ill.
the comparison is not just between the seriousness of the issues, but also about the deficiencies in the evidence.
Yes, but in relation to the public interest aspect of it, that's we say a factor to be considered. Now, I'll address the points that are taken against me as to the cogency and reliability of this evidence. You will have seen, I hope, the witness statements of Mr. Da Silva explaining and narrating that, and I don't need to go in very much detail through that, other than to point out. Well, I will ask you to turn it up at least. Could we begin on bottom of page 3? This is supplementary bundle 2. You see at bottom of paragraph page 3, paragraph 9, a number of doctors. Does every? Sorry.
No, we're there.
Yeah. Dr. Scheller from the USA, Professor Steinberg from Israel, who is also the chair of a committee that set out proposals for how Israeli law should deal with this sort of situation. Then Dr. Junger, Dr. Rothner, and I think Dr. Weiner, I don't think we have. But those doctors who all essentially tackle the same sort of issue, and I appreciate these are short reports, and there's probably sufficient said about each of them in Mr. Da Silva's witness statement, but they all say that the sort of evidence that led the doctors in the court below, whether they are the treating doctors or Dr. Hart and Dr. Samuels, to reach the conclusions they did, are that sort of evidence is essentially based on interpreting the evidence of observed movements and deciding the extent to which whether a reflex movement is properly described as pain. Now, I will come on when I address what Mr. Justice MacDonald decided to have a look at some of his findings and the extent to which it is appropriate to equate reflex or spasm with pain. And in my submission, Mr. Justice MacDonald went too far. But essentially, this evidence, and I appreciate that if in fact you were to do option 2 and send this case back for a rehearing, that evidence of this sort would need to be amplified, and Ms. Mulholland's observations as to the brevity of it, and the same in relation to the points made by Ms. Holleran on behalf of the Guardian. Obviously, those are points to be considered, but it is nevertheless the case that there is evidence that explains how something, an observed reflex response, is not pain as opposed to reflex, and reasons why that should be. I should also point out, and I'll take you to this when we get there, that in Rakib, there was similar sort of evidence about how Tafida Rakib presented. And Mr. Justice MacDonald in that case did not draw the conclusion that that similar observed behaviour in fact was as a result of her being in pain. Now, there was different evidence as to the state of her brain, and the cortical problems and so on are all...
It's very dangerous to compare facts.
It is very dangerous.
I think these cases may be similar, but the facts will often be crucially different.
Absolutely, and my primary point on the appeal is going to be that each case does have to be addressed for this child, and essentially what we say is that Mr. Justice MacDonald set out a list of factors for a child that was not appropriate for this particular child, and I'll make that submission in a moment. But coming back to the point I got to, I understand, of course, that you can't necessarily equate, but it is an example of how very difficult it is for any of these experts to give a definitive and precise opinion on something as subjective as pain.
A fact which was acknowledged by all the experts below.
Absolutely.
And by the judge.
Absolutely. And indeed, the evidence of Dr. A in her pain report, which I'll come to, is essentially narrates some of it to ancestral experience, some to what we all know because we walk about as human beings able to describe our feelings and so on. And what there was not, we say in this case, was any objective scientific test that helped one way or the other with the position. We had the EEGs, but what we did not have, in contrast, in fact, to Rakib, was any evidence of the, what I want to call the SSGs. I'll find the word in a moment. But essentially, this is not a case where it is vital that those who give an opinion of this sort have attended upon the person and taken a full history from the person and seen how they present and so on. In a sense, while of course any clinician would want to attend for the purposes of feeling that they had done what a doctor normally does, the fact that they haven't, and this is the point that's taken against the admission of this evidence, the fact that they haven't is not a reason to make that evidence unreliable or not credible, if we come back to lad number 3. So in broad terms, what we say is there is evidence from a number of clinicians who are ready and willing to attend and examine Alta, and that can be facilitated if the court thought it an important point, who have given, in my submission, reasonable and understandable contrary views on the issue of pain, which the judge below found, as we shall see when we look at his decision, to be decisive. So that's the medical evidence. There is now evidence about the arrangements that could be made to transfer Alta to Israel. And as is described in the evidence of Mr. Da Silva from paragraphs 45 and onwards, is very clear. There are a number of different facilities that would be willing and able to treat her.
Paragraph 21, are we on now, Mr. De Silva? 45.
45.
Okay, not the air ambulance. The hospital.
Treatment centres, and then we come to the air ambulance, yes.
Sorry, thank you.
Sorry, it's my fault, because I did.
No, it's my fault.
But in a sense, you can take that evidence together in my submission, because it's essentially there is somewhere for Alta to be treated and cared for. It may be of some significance that it's that the Hadassah University Medical Centre received a Nobel Peace Prize because of its treating people from all different backgrounds in the very different religious groups that make up the population of Israel. So is sensitive to religious issues and so on. And we have, and this is the evidence from it's at pages 61 of the exhibit, and 62 to 63 and 64, 66. A clear plan, a clear care plan as to how Alta's transportation to an Israeli facility would be organised. Now, there are two further points to make about that. The first is that one of the observations that Mr. Justice MacDonald made was that there wasn't very clear evidence about it, and indeed, my learned friend Ms. Mulholland's skeleton argument, position statement for the court below, drew attention to the paucity of the evidence before the court. There is now, in my submission, material that would address the concern that Mr. Justice MacDonald had identified for himself.
Of course, the judge concluded that, having noted that paucity, concluded that even if it was available, it would not have been.
That is right.
Paragraph 102 of his.
Absolutely, at 102, and you will notice that I did, when I was addressing the evidence in relation to pain, say that that was one of the things that was decisive for Mr. Justice MacDonald. This was a less important issue to him. He did make the finding that my Lord says, but nevertheless, in a case where one of the concerns raised by the Guardian in the court below is, well, is this a safe journey for Alta to make? That we now have evidence that it is a safe journey for her to make. Essentially, what's being capable of being lined up is a mobile intensive ITU on wings. And
insofar as she could be safely transported, that evidence, you say, if there was any doubt about it, that gap has now been filled.
Yes, yes. Then there's the opinion in relation to Israeli law, Dr. Weinroth. You will have seen, just as Ms. Mulholland and Ms. Holleran have seen, that is dated the 5th of May 2021.
Yes.
Page 67.
Yes.
I do not know why that wasn't supplied to the court. It maybe, and there's some discussion towards the end of the judgment below, that there was people didn't want to suggest to the court that if she went to Israel, well, I don't know what the reasons are. I haven't got any instructions on it. I've not tried to find out. But we say that rather than it being something that Mr. Justice MacDonald had a residual concern about, because he seemed to be concerned, well, will my order be followed if I make it and then she goes to Israel essentially to have treatment withdrawn and then people think better of it. We say, well, and this is how I'm going, when I begin the identification of some of the other points, we say, well, that's immaterial. If in fact this girl goes to Israel, receives treatment there, and under Israeli law, the law is, as set out by Mr. Weinroth in his opinion, then that's what the position is. That's where her best interests lie, because she is a Jewish Israeli girl whose value system is consistent with Israeli law. And it should also be said that Israeli law grapples with the same sorts of issues as we grapple with. It just comes to some different answers. But there is a Dying Patients Act that explains the circumstances in which a patient's treatment can be withdrawn from her.
She's habitually resident in this country, of course.
Yes. We don't take a jurisdiction point at all.
It isn't a jurisdiction argument.
Yeah, well, I can't say that she's not habitually resident, so nobody could make any orders at all. But what we do say is that it is highly relevant that she is also a citizen of Israel, and that her world outlook and her personal outlook would have far more connection with that country than it does with the day-to-day lives of children outside this very reclusive community in this country. And to the extent that, I mean, while we have to accept she's always, because of her disability, she has always been here, it would have been her intention, just as it has with the family and the older sibling, to travel frequently to Israel and to spend a lot of time there. And when I come to explain what the connection is to Israel and so on, very many of her extended family live in Israel, and very, very few live in this country.
But the family had moved here in 2014.
Yes.
And the plan, I may be wrong, I may have missed something. Was there a plan to move to Israel?
Well, sort of, in the sense that there's a lot of coming and going. I mean, it's in a sense, it's very difficult to answer my Lord's question in terms of precisely when that would have been or what would have happened, because of course in 2018 Alta is born and she has the very acute medical needs that mean that she's in the hospital, and how people respond to that, and it is obviously a very important factor that affects decisions either way. But I think it's a fair point, though. It's a fair observation to make that this family would have spent considerable periods of time in Israel, and whether you call that moving there permanently or whether you call that coming to and fro, I don't make positive submissions at the moment one way or the other. But this is essentially a Jewish family with a ultra-Orthodox outlook who have connections in very specific parts of the world, including Israel.
Yes. I just want to check with your junior whether you've got some instructions on that. I saw the rabbi
yes.
also note, and I'm conscious that it's difficult in the way the court is set up at the moment. So
Could I return to that, or
Yes.
is it something you'd like an answer to now?
No.
We'll deal with that because obviously it has a bearing on how we present the other. So, but dealing with the fact that she has Israeli nationality, there's also evidence from some very prominent people in that country to raising the concerns about what happens in this country to children who are nationals also of that country. I rather grandly refer to this in my note as some sort of international incident, but it is right to say that there is a concern in this particular community and around the world, including in the US, and I've mentioned that Mr. Fixler has also US nationality, and there's one of the letters that you'll see is from judges there. There is concern about the difference in decision making in the court below from how that would be for this national of who's also a national of another country, and we say that is all material, that when the court is informing itself about who is the person on whose behalf we are making a best interest decision, that they need to pay some heed to. So I think thematically I've addressed the issues that we say mean that this further evidence should be admitted, and also I've addressed the various aspects in a rather, I'm afraid I'm jumping about a bit within the Ladd and Marshall test, but fundamentally it is not purely Ladd and Marshall. The test is a different one, and I would also invite the court to consider the point that I've made towards the end of my note.
Last night's note.
Yes. That this is not just purely a question of Ladd and Marshall and cogency of evidence and sitting back dispassionately to assess whether in fact the evidence may make a difference to the outcome.
Where are you in your note?
I'm just leading you to paragraph 27.
Right.
This is not just a case about the sale price of a bungalow or commercial litigation and whether it's right to allow people to reopen issues that should have been dealt with before. There is also in my submission an important idea that the respect and legitimacy of any decision this court takes and the ability of the Fixlers to deal with it if it's adverse is also a relevant factor. And in my submission there is a difference between a family such as them thinking that there was material that the court refused to look at that would have made a difference, and the court recognising that and deciding to consider it and give it such weight as it might. And at paragraph 28, got an example from a different jurisdiction, but on a similar point of the impression that judicial decisions must make and the apparent fairness considerations that underlie it. I've set out from the page.
Yes. We've read that.
You've read
Have
that.
you now completed your observations on the fresh evidence preliminary point?
Yes, I think then. So I say that for all of those reasons, you should admit it under the broad discretion you have. Those are my submissions.
Thank you. So we'll deal with it as we discussed. Elisabeth, we'll deal with it as we discussed. Yes. Well, we're going to deal with this Abit de Bene essay, by which I mean we're going to.
Yes.
We've read it. We'll bear it in mind, but we're not making a decision about whether we admit it until we've heard the conclusion of the argument. So that gives you the scope to,
At least
if you, as you wish, to draw on it, bearing in mind that ultimately we may decide not to admit it.
yes, that's understood by you.
That's understood by you. And I think that to some extent meets the point you've just made about
Yes.
your
Yes,
the
I'm grateful.
importance to
I'm
your
grateful, my lord. I mean, I'm sorry it took me as long as it did to get to that point because I rather thought the court might ultimately take the decision it's taken. But anyway, with that in mind,
No, but it's been helpful to hear
Yes, thank
how
you.
you put it.
Yes, the pain. Just on now, I'll deal with it in.
How are you going to structure your submissions now? And
Yes.
can you give us this idea of the time? Because obviously, we must complete the hearing today.
Yes.
How do we? Can you set out a route map for
Yes.
us?
The route map is this. I want to begin with the very different considerations, some of the factual considerations of what this family's like. I want to take you to the test that Mr. Justice MacDonald formulated for himself and how he applied that. I want then to look at what the evidence in relation, the findings that he made about the significance or otherwise of religion, and the findings that he made in relation to pain. That's the and I say, or we say, that essentially the findings that he made in relation to pain turned out to be effectively decisive, should not have been made, and furthermore may, in the light of the ruling you've just made, be undermined potentially by fresh evidence.
Okay.
So,
So can you give us some idea? It would help Ms. Mulholland and Ms. Holleran too, no doubt, to know how long you think you will be now.
I'd hope to be an hour. I
Very
hope
good.
that's.
Very good.
It may spill beyond that, and if I will try and keep. I'll take my watch off and put it in front of me
That's
so I
right.
can see
No,
it.
no,
There are no
I
clocks
don't
in
want
here
you
anymore.
you're under no pressure.
No, I understand, my lord.
I do. It feels to us that the appeal should be. We should be able to finish the appeal hearing today. I very much want to. We all want to. Just so you know, Mr. Sibbett, I don't imagine we won't be giving judgment today, and I don't think we're going to be giving a decision today.
No.
But we do want to give our decision and judgment very quickly for obvious reasons.
Yeah, we're of course grateful for that.
Now, on the first point, the question about the family and the family circumstances.
Yes.
You've made. I don't want to stop you
Yes.
unnecessarily, but you should know that we have read very carefully the material that you've provided us with. For my part, I'm familiar. I've dealt with other cases involving people from the Hasidic community, so I'm familiar with the background, the beliefs, and the culture, and the way of life.
Yes.
But nonetheless, we've all read the material very carefully.
Yes.
So I don't think you need to spell it out in any great detail, but I no doubt you want to sketch it out.
Yeah, very
Somewhere.
briefly. Yeah, that part. Well, I was going to begin this by saying, you will have read my skeleton, paragraphh 7 to 9.
I should have waited.
Yeah, but no. Well, you probably shouldn't, having heard me so far. But no, that was
Well, I've heard you before, Mr. Sibbett. Yes.
Skeleton, paragraph 7 to 9, and in contrast, say, and I know we can't compare cases like that, but this girl Alta would have a very different life from, say, Tafida Rakib. She's not going to be going to ballet lessons or have much in common with children outside her community. She, and in a sense the comparator, may well be what her brother does.
Yes.
Goes to a separate school.
Oh, now I mentioned the brother. We've got some photographs.
Yes, I was going to ask you, yes.
I haven't had a look at them yet. I've been wanting to look at them. Can I look at them now?
What we have passed up, my lord, and I was going to deal with this when I was referring to the fact that we're on in person and not on video, is of course that's the sort of material that the court can and should receive, or can look at in this sort of hearing.
Well,
That's really cool. What we have...
Can we look at them now?
Yes, please, look at them and I'll tell you who they are.
Right. So we got 3 photographs.
Yes,
And the first is the photograph of Alta and her brother.
yes,
I'm guessing, is that right?
yes.
And then we have the family.
Yes,
And let me just have a look.
So which birthday are we celebrating? The second birthday.
I think that's right.
first birthday.
First.
Milady's seen the balloon in the top
Yes.
right hand
Yes,
corner.
And a huge cake
Where's the cake?
on the left, I think.
yes, behind the pillar.
Milady's spotted the cake.
Well, yeah.
And these are Mr. and Mrs. F.
Yes. Of course, because we're
I'm
all
pleased to
wearing
see
masks,
them.
it's
I'm pleased to
difficult
see them without their masks.
Yes, thank you.
Okay, and that's the brother proudly holding his sister.
Yes.
I ought to remind me how old he is now.
He's 5.
5.
So 8. 8.
Is he
8?
8? Oh, sorry.
He looks older than 5.
Yes, well, yes, sorry. He was 5 when she was born. That's what it
That's
confused
right.
me, my fault.
And there he is again with his,
There he is again with his dad
dad and Alta.
Yeah.
When were these photographs taken? Different time.
Yes. I didn't descend
yeah.
to
All right.
taking
Well,
very detailed. I knew the family wanted the court at least to see Alta and to see the family. So it's in that context they provide. I haven't.
Well, as you know, Mr. Sir, so the judges here in these cases always like, if possible, to see the photographs, and perhaps Mr. Justice MacDonald didn't have that opportunity.
No, I don't know that he. Well,
I know he would have wanted to.
My learned friend, one of my learned friends is nodding, saying that he did see something.
Well, he would definitely have wanted
yeah,
to.
Thank
Hadn't
you.
he? It's a shame that if he didn't.
Well,
There we are.
What he wouldn't have got the opportunity, of course, was having people before him in the way that you have, and having the family along attending. That's
Yes.
just where we are.
Well, I've already said how pleased I am we're here together.
Now, this is the family. These are the way they dress,
Yes.
their outlook, and so on. Is a very different one from other people born in the same place as Alta was born, and in fact their wider family are almost all in Israel. Mr. Fixler's parents are there. He has 3 brothers there, 4 sisters. He still has 2 grandparents alive, and some uncles and aunts.
They're all there, are they?
They're all in Israel. Mrs. Fixler's parents are there, her 2 sisters. I think they must be unmarried sisters, because she's got a married brother and a married sister on top of that, also in Israel. She also has grandparents and uncles and aunts. So that all of the wider family is in Israel. So to answer,
Are there any members of the wider family here?
I think not.
The answer to my question is yes.
I mean, I was working by a process of, well, there's a lot of people that aren't here, so that seems to be the I think there may be some siblings here, but that we can answer that.
There are some here, but,
Yeah.
but most of the extended family are in Israel. Would that be
Yes,
fair?
almost all.
Most.
And all part of the same community.
Yes,
Yeah.
all part of the same community, and that raises a point that I've made observed in the skeleton, but ought to cite formally to the court. If you could turn up, please, in the authorities bundle, tab 10.
Right. That's 1. No, it's 2.
No, that's the one.
It's 1. Last one. Managed to get. One of the disadvantages of being in court is you have everything on paper, so you end up with all 4 bundles open. Yeah. Tab 1.
Tab 10.
Tab 10. Bundle
The
1.
judgment of Mrs. Justice Hale
As she then was.
in Re J.
Hang on.
No, this is
And Mrs. Justice Hale. She was.
Oh, sorry, she was Lady Hale in the house.
Yes.
Yes. Right, sorry.
You know what? We both had a.
What it is
Well,
I've
it's
written
madness.
Hale Re J, and I've conflated that. Lady Hale in Re J, custody rights, tab
Yes.
10. Custody dispute between 2 parents who'd been Islamically married and met in Saudi Arabia, and the mother brought the child to the UK. The child was a UK and US and Saudi citizen, and various a custody dispute arose, and the court's not concerned with the resolution of the custody dispute. What I say the court should be concerned with is what Lady Hale said at paragraphs 36
Will you quote this to
38.
You can quote
And
this.
essentially, this is a situation in which there are very many different possible outcomes. And at 37, she says it would be wrong, in the middle of the second sentence, 37, it would be wrong to say the future of every child within the jurisdiction of our courts should be decided according to a conception of child welfare which exactly corresponds to that which is current here. In a world which values difference, one culture is not inevitably referred to another. You will not have any fixed concept of what will be in the best interest of the individual child. And I've cited just a couple of sentences in the skeleton, but I say the whole of 36 to 38 is an important principle. I've referred to the international aspect of it, different cultures. She also says exactly corresponds to that which is current here. And as a graphic example of how attitudes in this country have changed, Re B at tab 1, which is a case Mr. Justice MacDonald cited for himself as being part of the legal matrix, that you needn't turn it up, but what it is about is a case in which what was described only 40 years ago as throughout the judgment as a Mongol or Mongoloid girl had been in best interest proceedings where the judge, the parents and the doctors thought that it was appropriate that she should be denied a life-saving operation, and the Court of Appeal decided this was wrong because the court was not going to allow the parents to use Lord Justice Dunn's words, condemn a child to die, and it was necessary to preserve this baby's life. And I cite that only to show that attitudes within this country change over time. The first instance judge thought that a child that nobody would be taking, this issue wouldn't arise now on those facts.
Well, attitudes to disability change fundamentally.
Absolutely. And one of the core points we make is that when it comes to Alta's religion, she is born into that religion. It is not a matter of cognitive decision making. It is part of her culture and who she is, and that essentially it is wrong to deprive her of her religious values and religious culture because she has a disability. And looking at how, in fact, things unfolded in this case, we say Mr. Justice MacDonald misunderstood the importance and fundamental nature of her religion and religious tradition, and essentially took the wrong starting point and wrongly left out of account the fundamental nature of religion. And just before I show you where he did that, and to say what he actually did, dealing with just to box off the difference in points of this community and others, it is of course a fundamental responsibility of the court to ensure that there is no discrimination suffered by people who profess a particular religion. There is the profound comment in a case with a different context, but nevertheless a different about the importance of right to profess religion, and in fact, as it happens, an aspect of the Jewish faith. In the Adath Yisrael case, tab 24 of the authorities, please. Yes, sir. If my lady would tell me where bundle 1 ends, yes. I'll try and do it myself.
After 10.
Right, thank you. Right.
Thank you. Yes.
The Adath Yisrael Burial Society was a judicial review of arrangements made by of the fact that a coroner essentially operated a cab rank rule in relation to post-mortem resources being made available, and the complaint was that this had a discriminatory effect on certain religions, including the Jewish faith, whereas the headnote records between D and E, there is an expectation that that the funeral of a deceased person should take place as soon as possible, ideally on the day of death itself. And the reason I read that out in detail is because, of course, one facet of our case is that it is important and auspicious to think about what will happen when Alta dies and the relevance of her being in Israel for that. So Jewish customary law requires the funeral as soon as possible. And the coroner didn't make any sort of, operated the cab rank rules as I've described. But at beginning at paragraph 93, there's a detailed exposition of Article 9, and I needn't invite you to read that in detail now, but I do want you to arrive at paragraphs 111 and 112, where Lord Justice Singh made what in my submission is the profound observation at the end of 111, that in other words, to treat everyone in the same way is not necessarily to treat them equally. Uniformity is not the same thing as equality. And then using that, he found violations of Article 9 and Article 14 in the way that the policy was being operated. And the same point that he's made there is made at paragraph 117 of the same judgment, where he says, although the principle of equality requires like cases to be treated alike, it is not always sufficiently appreciated. It requires that different cases should be treated differently. So if I had to put my case, as it were, in two sentences, it would be that Mr. Justice MacDonald set out an approach that he thought was suitable for a child, and he inadequately and incompletely addressed his test through this child. Now, what we say is the starting point is this child, this family, these parents, and how they think and operate. One of we had the discussion earlier about the difficulties there'd been in visitation and so on, but one of the things that they did do was when, as part of the way in which their community, which is essentially a community of study and reflection and trying to, by studying, reach the correct religious outcomes to all sorts of situations, they have been, they responded, as in fact is in the evidence from Mr. Fixler, to this terrible situation in which their daughter was so ill, by seeking all sorts of religious guidance and instruction from rabbis and so on. So when we actually look at who is Alta, what are her values, what are her parents' values, they are intensely religious. And we say the judge just hasn't begun to engage with that in any meaningful sense. And I'll come on to the specific paragraphs where he essentially concludes that because Alta is very young and can't have thought these things out for herself, that the religion should be less important. We say
is 95.
Yes, we say that is fundamentally wrong. You are born into a religion, you are born into a culture. In this case, it's also a race.
I mean, it's important not to generalise. You say Alta was born into a religion. Some people are not.
Yes.
So
Yes,
Alta
Alta was born into a religion.
Alta was born into a cult.
My lady is, of course, correct. It's I was misstating it in terms of uniformity rather than the individual. She, and there can be no sensible evidence to the contrary in my submission. And again, we'll come on to 95 to 96 to the inferences. There can be no sensible thought that anything other than that Alta wouldn't share those values.
But this approach is essential in every case involving a child. Every case, the statute requires the court to take into account a child's characteristics and background.
It does. One thing my Lord will, I hope, have noticed was not present in Mr. Justice MacDonald's judgment was the setting out of the Section 1, subsection 3 test.
Yes, but
we
don't expect judges to do that.
Well, he did do it in Rakib, and in many of the other cases, including the MB case, which Mr. Justice Holman cited, he did set out the statutory test. And we say what's important here is that this is a Section 8 application.
Well, it's both. It's a Section 8 application and an application under the inherent jurisdiction.
Yes.
Either way, the Section 1.3, well, as a matter of statutory interpretation, the Section 1.3 criteria apply under the Section 8 application. But as a matter of practice, they apply to all children's applications.
Yes, but under the Section 8 application, then it's also necessary to look at Section 1.2a. Because this
1.2a.
Yes, 1.2 big A.
Yes.
Because this is a case where the statutory presumption applies that the involvement of the parent in the life of the child will further the child's welfare. So there is a specific and additional statutory requirement for the judge to take account of the fact that, unlike, say, the child in the Kirklees case, Kirklees is a case, we've put that in the bundle because Mr. Justice MacDonald cites it, who was in care, this child is in the care of her parents. And while we don't say, and can't say as a result of the decisions in Yates and the and the explanation of remarks my Lord had made in King and so on, while we don't say that there's any requirement of threshold or anything like that, that when one applies the statutory test under Section 3 in the welfare checklist, this child is in the care of parents who have parental responsibility, as defined under Section 3, which is it's at the end of the authorities bundle, and therefore the presumption in Section the way it operates is that the presumption in Section 1(2) big A applies. There should be a presumption that the involvement of the parent in the life of the child will further the child's welfare. Well, when you look at how Mr. Justice MacDonald set it out at paragraph 57, he gave the parents a very limited importance in his own test of what he thought should be best interest. And then at paragraph 105,
Sorry, so
Mr. Justice MacDonald,
yes.
57,
Yes.
he sets out his workings. I've made the point that Section 1(3) is not present there.
I see.
When you go through the list of things in paragraph 57 of Mr. Justice MacDonald's judgment.
Right, so Roman numeral 9 is not enough, either in ranking or substance.
Yes. He doesn't say I have to apply a presumption that it's to the child's benefit to be brought up by their parent.
Well, just a moment. First of all, where do you, of course, that's not controversial, but what are you quoting there?
Well,
we're not quoting. That's not
we're
what
quoting
section
the
one,
absence.
That's not what Section 1(2)a says. What you just said, where you put it is not what Section 1(2)a says.
Section 1(2)a.
You said be brought up by their parent.
The presumption that the involvement of that parent in the life of the child. That's how I read it out earlier.
Yeah, it is how you read it earlier, but it's not what you just said. You said actually
will
brought up.
further the child's welfare.
Yeah.
That presumption is nowhere referred to by Mr. Justice MacDonald at paragraph 57, and indeed, if anything, he rather minimises the importance of the parental role and puts it at either equal to or below the importance he gives to the views of clinicians.
But is there any, help me, I could be wrong here, but what is meant here by involvement? Is this talking about the sort of involvement you're talking about, which is giving weight to their views and their beliefs, or is this involvement of a more practical kind?
Well, I would say both, my lady, because it's a feature of virtually any situation involving the welfare of a child living with her parents, that they will, when she's a baby, take virtually all the decisions that they think are important. They decide how they'll dress.
Is there any law on that, on the meaning of involvement?
I've not come across any, but
No.
I don't recall Section 1.2a being cited to me before, actually, Mr. Simblett.
but I am right on it. I mean,
What? You're right. Yes, you're right, it's there, and you're right. You,
I'm right, and
say for once, on
and
one
I'm right
occasion, you
as-
read it
as
out
to-
correctly.
And I'm right as to how it cross-refers to Section 1, subsection 6, as to be the...
And so, and we're in a 4A situation.
Yeah.
Circumstances mentioned in subsection 4A
Yes,
or 7.
yes, it's all very clumsily drafted, cross-referring to each other, but essentially, by a combination of Section 1.2a, Section 1.4a, Section 1.6, and Section 8. Or sorry, those things, that on a Section 8 application.
Sorry, in fact, the answer to my question is in 2B. It means involvement of some kind, either direct or indirect. But not, you see, so that does suggest it's all about division of a child's time. Does my lord have the 2B?
Yes,
Yes,
it
well,
does.
generally it is. I mean, generally a Section 8 application is where somebody wants to go and take the child to Timbuktu and the other parent doesn't want to.
I'd have to remind myself, and I will remind myself, of exactly the origins of this amendment. It was introduced it must have been introduced in the 2014 Act
Yes.
as a way of reinforcing the importance of contact.
Yes,
So
That's that I think I'm guessing.
yes.
As an educated guess.
But nevertheless, it does mean what it says, and in my submission, it does remind us all that where a child is in the care of her parents, she should be in a different position from a child who is a ward of court. And Mr. Justice MacDonald somewhat conflates the authorities where the child on wardship with the cases where the child
But most
isn't
of
a ward.
the children, nearly all the children who are subject to these types of very difficult application are in the care of their parents.
Yes, but it's
And what Mr. Justice MacDonald is doing in these paragraphs is summarising the law as established in all the authorities up to and including Pippa Knight.
he's summarising the law, but he equates the cases on wardship with the cases where the child is in the care of their parents, and he equates the
Why is
law in
the
the case of
child
local
who- why is
authorities. So
the child-
Kirklees was in local authorities.
Why is a child who's a ward of court not entitled to the same treatment under 2A as a child who isn't?
Well, it might be that they should, but the actual statutory position and the context is that this child is in the care of her parents rather than, say, the child in Kirklees in the care of local authority, and that what her parents would normally decide about how she should be dressed, what she does, where she goes, all of those things.
This applies to all parents, even children who are in care, doesn't it?
Yes, but when you come to, in certain circumstances, of course, the difficulty if the child is already in care is that certain judgments will have to be made as to the weight and so on that has to be given to parental views. But this child, we say, Section 1.2a means what it says, and there's a presumption that the parents should be at the forefront, essentially.
At the moment, for
deciding
my
what-
part, I don't see how Section 1.2a adds to your case, Mr. Simpson.
Well, I shall move on. I'm not. If I can improve on the
For my
submission in
part,
reply.
for my part, I think the position, the importance of your client's views would be the same whether or not 2A was there.
It's also, we say that he also, and this is, if you then turn to, I'm still dealing with the position of the parents. If you then turn to paragraph 105,
In the judgment.
in Mr. Justice MacDonald's judgment, that he says, I'll read the second, read all of it yourselves, but in the particular the bit I wanted to read out was the middle of the paragraph. The court must also be mindful the views of the parents may understandably be coloured by emotion. All I'm satisfied in this case is important to examine the views of the parents, particularly in circumstances where those views crystallise around strongly held religious convictions, and the weight the parents contend the court should place the factor in reaching the
Well,
best interest
isn't that an
decision.
important point against your submissions here? Doesn't that show the judge had in mind the importance of your client's views?
Well, no, we say that he warns himself against their views being coloured by emotion.
Yeah,
Pausing there. In this case, what we don't have are views coloured by emotion. We have, in fact, views that are very influenced by a very detached, rabbinical,
But that's really what he's saying in the last sentence.
Yeah,
Notwithstanding that, I'm afraid, I bear in mind, he says, that views can be coloured by emotion. But in this case, I'm stressing certain words, in this case, it's important to examine the views of the parents in circumstances where they crystallise around their strongly held religious convictions. Isn't that the judge reminding himself of the importance of attaching weight and considering carefully your client's views in the context of their convictions?
Well, it might have been if he hadn't said what he'd said in paragraph 106, and particularly towards the end of that, last couple of sentences, where finishing with, within this context and self-evidently, the analysis the court must undertake is much wider in its ambit than the rabbinical analysis that informs the position taken by the parents in this case. And he goes on to the questions of suffering and the need to take account of.
Well, what he says is that you and the key word in the next paragraph is the word all, which he's emphasised. You take into account all relevant factors.
Yes. Well, essentially, we say that that's what he said he was doing, but he didn't properly appreciate the intensity and profundity of the religious way of life in this case.
Well, he said the spiritual considerations the parents urge upon the court fall to be considered alongside the very worldly issue of the consistent pain that the court is satisfied alter experiences. Don't be distracted by consistent at this point. We'll come back to that.
Well, I'll come back to the earlier part of the judgment where he rather discounts the idea that alter would share the religious views.
So this
of
is
the parents.
This is 95.
Yeah. So
is it?
in
I don't want to take you out of turn.
No,
I'm conscious I'm slightly
Yes, I understand.
pushing you.
I'll
take whatever course you want.
Well, yeah. Can I just deal with it in this way? That this isn't essentially the way he's expressed himself. We say undervalues the role of parental opinion in this case.
But Mr. Simler, what weight are you saying the judge should have given? I mean, in paragraph 108, he makes it absolutely clear that he has considered carefully and accorded respect to the views of the parents and the evidence of Rabbi Goldberg. And then he says, but he's not satisfied that the strict religious principles outweigh other compelling factors.
Well, what we say about that is two things. The first is, and the answer to the outweighing compelling factors, I will address you on pain in a moment. So that's further down the road. So
yes, but he's given value and weight to these matters. What's wrong with that?
Well, that he hasn't, because he regarded faith and their way of life as somewhat of an intellectual exercise, rather than going to the very core of who Alta and her family are.
Intellectual exercise.
Yes.
Why do you say that?
Well, because, and this is going back to 95 and 96 and so on, he...
You mean cognitive?
Yes, cognitive, I suppose, or rational.
Okay, well, we're now at 95.
Let's go to 95.
These are the key, probably the key paragraphs.
These are the key
for
points.
your
I am going
point.
to overlay it with Article 8 and Article 9 in a moment. But
yes.
What he says at 95 and 96, nothing wrong with the first sentence of 95, but it goes wrong after that. Of course, it's difficult for any judge to put himself in the shoes of a 2-year-old, but unfortunately, he gets to the point, having accepted in the middle of that paragraph, a child's attitude may be, indeed often is, influenced by the views, beliefs and guidance of his or her parents, but the child remains an individual in his or her own right. In some cases, of which Rakib was an example, there may be evidence that will allow the court to make an informed judgment as to the extent to which a child shares in their parents' values and the values of their community, and factor that into the overall evaluation of best interest. That is not the case here. Alta is not of an age, nor in a condition, to have knowledge of and to adopt her parents' values from which she could extrapolate a position on the complex issues that arise in this case. Well, the trouble with that is that he rather leaves it up to the 2-year-old to decide whether she believes the values of her parents and assumes that in the absence of evidence that she does...
Well, that's in the first paragraph of the next... first sentence
yes,
of the next
and then
paragraph.
goes on, yes, in these circumstances and absent any evidence to assist the court in determining the extent to which Alta would adopt the wholesale views of her
Sorry, I
parents.
interrupted what was an important sentence. What the judge does wrong is he leaves it up to a 2-year-old to decide and assumes in the absence of evidence...
That she... And assumes in the absence of evidence that she wouldn't decide it, or that the inference should be that she hasn't.
Well, he deals with it in the way he says in the sentence that Milady just referred you to.
Yes.
The first sentence of paragraph 96, in which he says, in the absence of evidence to assist the court in determining the extent to which she would adopt wholesale the views of her parents, the furthest the court can safely go in seeking to place itself in her shoes is to acknowledge that a child's attitude may be and often is influenced by the views, beliefs and guidance of his or her parents.
Yes, maybe. And then he said...
And often is.
Yes, and often is. But then he says... But then he goes on, as my Lady Justice Carr has just read out. The first sentence of paragraph 96, in these circumstances, and absent any evidence to assist the court in determining the extent of and then the next sentence is also important. He says the furthest the court can safely...
Yes, I've just...
that's what you read.
That's what I read out.
Yes, within this context, I have to hold in mind the strict religious creed they adopt.
So what do you say? Do you say that he should have said that he did have evidence to assist? And he had the evidence of the community, he had the evidence of the brother. What it should have erred in failing to find that she was bound to have adopted her parents' beliefs?
We don't need to go as far as bound. We say he had evidence of how the family lived. He had a comparator, if we use the Equality Act language, in the form of the brother. He had the fact that religion in this family's case, appreciating the correction from my lady earlier, that these people are born into this faith, and he had no evidence, no material upon which it would have been right to take away all of those features. But that is in fact what he then does.
So what? So you're saying he erred in... Forgive me.
No, you go.
He erred in failing to not to go further in his satisfaction. What should he have found, you say?
He should have found that Alta's values were that she had been born a Jew, of race and religion, that she was an ultra-religious Jewish girl who would wish to follow Jewish law, and that much of the time, indeed almost all the time, when any issue arose, that what you do is you ask the rabbi or the rabbinical courts for an answer.
Okay.
There is no evidence. Look, if we put it in terms of the other way, of inferences and so on, where was the evidence that Alter would not do that?
Well, let's look at he didn't do. He didn't do that. What you said is not his approach. But let's look at what his approach was. You say, where is the evidence? There's almost a presumption that being brought up in this community, she would have had the right. Is that what you're saying?
We're saying, yes, and that is not just that, and this comes back to my formulating it as religion and as a cognitive exercise. It's who she is. It's her identity. And I've raised in the skeleton the fact that this case, as argued before Mr. Justice MacDonald, has quite a lot to say about the extent to which rights under Article 9 and so on should be afforded. But this is actually about who this girl is.
Yeah, who is Alter?
And Article 8. Who is Alter?
Sure.
And one of the cases that we cited was Mikulic in Croatia, where the European Court told us more about what identity means. Tab 7, so that's bundle 1. Mikulic is in fact a case. It's nothing to do with this sort of situation. It's a case about whether or not a state should require or put in place steps to enable an adopted child to find out who their birth father was. And there's been a subsequent case that says there are other considerations involving Serbia. But anyway, I'm not interested in the outcome of that. I'm interested in paragraphs 53 to 57, where we see what private life under Article 8 means.
Sorry, what tab are we?
Tab 7.
Tab 7.
Bundle 1.
Bundle 1, paragraph 53.
This derives from Niemitz.
Derived from Niemitz and is then explained. So private life, in the court's view, includes a person's physical and psychological integrity and can sometimes embrace aspects of an individual's physical and social identity. Respect for private life must also comprise, to a certain degree, the right to establish relationship with human beings. That's the Niemitz point. Then there's the paragraph 54. The court has held respect for private life requires everyone should be able to establish details of their identity as individual human beings, and an individual's entitlement to such information is of importance because it's formative implication for his or her personality. And I think we needn't see much more, apart from to observe, of course, that there can be positive obligations as set out.
Can we go back to 95 and 96? And you set out your story as to what the judge should have done. And let's look at what he actually did. What he did was he assessed welfare best interest in the widest sense.
Yes.
That's what he was required to do.
Yes.
Entry, etc.
But he took the wrong starting point. His finding.
Why do you say?
Finding at the end of.
Where's the starting point? Where's that?
Well, on this starting point, on this issue, we're saying at the last sentence of paragraph 95 that we've just read it. She's not of an age nor a condition to have knowledge of and to adopt her parents' values, from which she could extrapolate a position on the complex issues that arise in this case. Well, that's, we say, wrong. She is a girl with all of the characteristics that we've been discussing within this community, and that is her value set, or to use the language I've just used from Article 8, that's her identity. So what he does instead of that is
there's no evidence. There's no evidence. You say that he could have taken. There was evidence, and that the evidence was the family.
There was very
circumstance.
strong evidence,
Yeah,
we
okay.
say.
But in the abstract, he says the furthest the court can go is to acknowledge their attitudes may be and often is influenced by the views, beliefs, and guidance of parents, and he considers that in the context of the religious credo of the parents and the tenants, and that you can't assume that a profoundly disabled child would want to stop treatment.
And you can't assume that the disabled life would not wish to lead
Yes.
life affected by disability.
Yes. So those are points that he takes it. Accepted your premise that he doesn't start in the right place. He does take those points into account in the evaluation, which are points which indicate he is taking indicates he is taking into account the values which the parents have.
Well, my lord, no, because although he understands the strict religious credo and mentions it, what he doesn't do is properly understand how dreadful for them and for her community the idea that treatment be withdrawn would be. And it's also important to put this along.
Is it a question of degree?
Well, no, it's a question of he sets these things, he mentions these things, but because, and I say that the last sentence of paragraph 95 is extremely important because that's his starting point then to get into paragraph 96. He instead of assuming that she does share her parents' values, essentially he starts from the position that she doesn't, because there isn't evidence to support it. And then he sets it out, and then, so really the answer to my lord's question is, he from that starting point then goes on to the various issues that would apply to a child. But he's not doing this child, because he's already decided that this child doesn't, that he doesn't have evidence that she is who her parents say she is.
Mr. Liu will have an injury if you don't take his note. Hopefully we're going to get rid of these barriers soon. Yes. I see the way you put it.
Well, sorry, this point does also need, and this I highlighted this for myself, and this is what Mr. Liu was keen to convey, that also he had already made the finding at paragraph 72 in relation to the Jewish belief system, that this was one, to use Mr. Justice MacDonald's emphasis, factor to be weighed in the balance when reaching a best interest decision. We say it's not just one of several, this is the core starting point. So we ought to look back at 72
Okay.
again, but just
Rather than Mr. Liu, we'll look at 72.
When you combine 72 with the last sentence of 95 and the first few sentences of 96, while we then see various sort of things that somebody might look at in relation to a particular person and their particular views, what you don't see is the core identity of this girl and this family permeating through the approach that Mr. Justice MacDonald followed below. And so essentially he has taken the wrong starting point. And although he mentions these things, he mentions them as if they might be just might be things that you might think about, rather than actually how important those are going to be if you've chosen the correct starting point. I think that's as well as I can articulate point at this stage.
For my part, you've articulated it extremely clearly.
And I should also say that, of course, this needs also to be put in the context of the international aspect of this and the alternative plans. That actually, what would she, if you could ask Alta, and you accept that those are the values that she has, what would she say? She would say, I would like to go to Israel. I would like my parents' values to be respected and followed. If I am to live a short life, as my name signifies, and you will have seen the symbolism of the name Alta as meaning long life, often given to a child with vulnerabilities, she would think, as and when I am gone, I will want my parents not to be given further anguish. So it's also about dying as well, this case. We also say that Article 8 and the identity issues and so on are not just about a process of formulating best interest as a choice between life and death in the way Mr. Justice MacDonald's formulated, but also to think about, well, what will happen after I've died? And what will happen after she has died is that, as required by customary Jewish law, as discussed in the coroner's case that we looked at a few moments ago, there is a religious imperative to be buried as soon as possible and in any event within 24 hours. There is no practical possibility of anybody setting up a burial in Israel within that time scale. And although Mr. Justice MacDonald dealt with that topic very briefly at paragraph 111, he gave it very little, if any, consideration, and finished that paragraph by saying this: I'm not satisfied that these spiritual benefits are sufficient to outweigh the additional burden of pain that would be placed on Alta by a transfer. Again, particularly in circumstances whilst not spiritually optimal, it is possible to transfer Alta for burial in Israel following her death in this jurisdiction. Well, we come back then to the treating people uniformly is not equal treatment. And insofar as that involves a breach of the very strong religious imperative to be buried as soon as possible and within 24 hours, or if what is meant, and we don't need to drill down to it, that in some way she could be reinterred or something, each of those would raise profound and difficult issues. So if you come back to section 1.3, best interests, whatever we say, and look at what would Alta do, she would start from the starting point that she would want to follow rabbinical practice because that's what her parents do, and she would have very great concerns for what might happen to those left behind. So we say that it was of very great importance to choose the right starting point, and that the judge in not doing so has essentially got it wrong. Now, I wanted to move. I said I'd be to about 12:30. I think I'm going to be longer than that. I'll move now to pain.
Yes, well, I think you've covered 1, 2, 3.
Yeah, we have.
Now you're on to 4.
Yes, so moving then on to pain. I've already, my lord, my ladies, addressed in relation to the application to adduce the fresh evidence the way in which the medical material unfolded. But it's important, we say, to look at what the nature of the evidence in relation to pain was. And essentially the submission I make is that permeating the evidence is what would appear to be a degree of interchangeability between the word pain and what might more properly be described as discomfort. And to give you some references to the evidence, and then to come back to what how Mr. Justice MacDonald approached it, in relation to Dr. A.
Can I just ask you to help me with this? What is your target threshold here? You challenge the judge's finding of fact as being irrational, perverse?
We say that he made a finding that he was not entitled to make on the evidence,
Right.
and then gave it essentially decisive weight to negate all the points that I've been submitting about earlier in relation to who Alta was and what her values were.
So, perverse or irrational finding of fact and then undue excessive weight?
Yes. As any advocate hesitates before immediately accepting the encapsulation of his case in the
Well, Milady does sum up the
Well,
how
I'm
we
just
got
trying
yes,
to-
but
I'm trying to get my own
that is
minds
that is of
clear.
course entirely uncontroversial and the test. So yes, that's
Because it's obviously a high test.
Yes, of
high
course.
threshold test.
Of course.
On the first limb of that.
yes.
And we don't have, do we? How clear are we about what was said in oral evidence?
We're very there's no transcript.
No.
There's no agreed note
And
or
the judge
anything like that.
refers to the oral
He does.
what was said in oral evidence
He does.
in his. So you don't know the extent to which this
I don't.
particular point was
But
traversed.
that has to be confronted. We don't know that. The judge does make the findings that he does. What I propose to do is refer to some of the written evidence and also to some of the things that were not there. I've already, this was the term I was looking for when I was discussing the underlying objective evidence. What there was not in this case was any somatosensory evoked potentials tests, which are the way in which somebody tries to assess how well the nervous system is functioning. And that, of course, plays a key part in this case because it's the nervous system that's the receptor and transmitter to the cortex.
So I'm just pausing, Mr. Simlet, and not writing, as you can see, because I'm just wondering how, in the circumstances in which my Lord has described, we could possibly overturn the finding of fact. I mean, there may be other options to you, but how can we possibly overturn the judge's findings of fact by reference to the written material alone when there was material oral evidence about which we know nothing?
Well, we do know the point that I was making
We
when my lady interrupted me. We know that's right.
We do, and because
Yeah.
I mean, is it your position that even with the limitations just discussed, we can describe and make a finding that the judge's finding was perverse, or is your realistic target at best remission of some sort? Think about it.
I will think about that. I will think about the consequences of that because there are a number of one of the points that we actually need to look at is what actual order he made and what the effect of it is, it being a declaration and so on. But the trying to set the context for what there was in relation to pain. Let's put the findings of the judge. Well, let's look at how what the judge had available to him, and then go to the findings that he made on the material as explained in his judgment. One, in relation to pain, the general point, and I'll give you some specific references in a moment. There is, in my submission, an elision between pain, in quotes, and discomfort, in quotes. There was no clinical measurement, whether by somatosensory evoked potential test or otherwise, of how any measure of pain. There was no clinical measurement underpinning anything that the judge was making findings about. There was no idea of the intensity of the pain suffered in these discrete episodes. And the evidence the evidence was not that Alta was in constant and unremitting pain, but was instead consistently, brackets, though not always, suffering or exhibiting symptoms of isolated, albeit frequent, responses indicative of discomfort. And those are the three things that in
Say
my...
frequent or not frequent?
No, it is frequent, albeit frequent.
Albeit
but not every time. So
yes.
essentially the evidence was...
discomfort.
Yes, the evidence was that when she was
Touched or moved.
she would move around, or touched or moved, she would move around for periods of around 30 seconds.
Spasms,
Yes.
clonus.
Yes, clonus spasms. And also the evidence was, and this is taking it from the judge's findings, that was not always the case, that every time somebody touched her she did that. But I've, in fairness to the overall picture and the ability of the judge to make the findings he did, accepted that this will be frequent because it is frequently the case that she needs to be touched.
And the judge used the word consistent.
Yes.
As a sort of word to summarise all that.
Yes.
Might not have been everybody's word, but that's what he meant by it.
Yes. Well,
I distinguished it from constant.
yeah. I say it's significant that it wasn't constant.
Yeah.
Because when we come back to the weight that was placed on this factor, and I also say it's significant that there was no evidence of the intensity of it, and that essentially the evidence was of these movements which are consistent with discomfort. And when we look at what Dr. B said about it and Dr. A, characterised by it being impossible to know how much Alta feels.
Yes. Well, the judge considered all that carefully. And the judge concluded it was pain, not discomfort.
He concluded it was, he was, and I can't say that he wasn't entitled to call it pain.
Yes.
But I can say that what takes him there is essentially a deduction from the doctors from whom he heard that these spasms and signs of discomfort should be described as pain.
Okay.
I know that's a fairly tortuous way of putting it.
It is, but I mean, can we take this short in the light of what you said to Milady as well, that you can't really challenge his conclusion because it was open to him.
I can't challenge his conclusion that he could find that she suffered consistent pain
In the way that he used the word consistent.
in the way that he
And you
used
helped me
in the way that he
some.
used it.
Yes.
But I can say that the fact that he knew that he didn't have any objective clinical measure should inform the treatment that he gives to that finding in the overall evaluation of best interest.
Should it mean you're saying he should therefore have given less weight to his finding?
Yes.
That she suffered consistent pain, but not
Yes.
frequent, consistent, but not constant pain.
Yes. And in fact, what he did was he gave it decisive weight. And
Why does he didn't have the clinical measurements, but why does that undermine the weight to be attached to his finding?
Because when you're looking at if you're trying to take a decision on somebody else's behalf and think, what would they do and what should I do? One of the factors that you ought to take into account is the confidence with which you've been able to make the findings.
Surely a finding's a finding.
I mean, I understand. Obviously, I don't want to revisit sex abuse case, and the finding is on the balance of probabilities, of course.
Well, we're in danger. Yes, you are in danger of reviving the more serious the allegation, the more cogent the evidence must be.
Oh yes, no, I'm not.
Of course, there are those who think that approach should be revived, but the law is clear in
Yes.
family cases.
Yes, yes. Well, in fact, it's clear in all cases.
Yes,
isn't it? Because that's
it is
used
clear in all
yeah.
cases, but there's sort of view that it shouldn't be. But that is
Yes.
undoubtedly the position. And isn't that the point? Isn't that with respect to the mistake you're now making? You're saying simply because there could have been stronger evidence, we should discount the finding that the judge made on the evidence available to him.
Well, no, it's more nuanced than that. I would say that if, for instance, the judge had objective evidence that there was unremitting, very acute pain, then that is something that you would give substantial weight to. But where you know,
I sort of understand your point. You would say if you're certain about something in a situation like this, then that's one thing. If you think it's likely, but there's an element of doubt, then maybe that is a permissible consideration.
it must be relevant in my submission as to whether you make that thing the decisive factor, which effectively in this case it was, between deciding that it was in Alta's best interests to have treatment withdrawn and that she should die, as opposed to any of the other outcomes available on this application.
But we make findings on the balance probability.
We make findings
on
on
the basis of the
balance.
evidence before us. And although you've said there wasn't clinical measurements, you're right about that. There was a lot of evidence, not all of which we've got because you haven't got the transcripts. There was a lot of evidence about, for example, I don't want to distress the parents, detailed evidence about the condition of Alta's brain, and which parts were still
Yes.
functioning. Which was
Surprisingly, the EEG, she seemed to be improving in some respects. But anyway, that's
the
it.
key point is that he the evidence on this issue is the evidence he heard about the parts of the brain that would experience pain.
Yes, but I mean,
Now, my point, I don't want to go down that sidetrack. I just want to. My point is that it wasn't as if he had no evidence. He didn't have the measurements that you say would have been, as it were, the gold standard. But my words, not yours.
Yeah.
But he had a lot of other evidence, didn't he, on which he reached his finding on a balance probabilities.
He had evidence on which he could conclude on the balance of probabilities that there were episodes of discomfort that could properly be called pain, albeit with no idea of the intensity of that pain. That's what he had. And it's, and again, this is an appeal. We are where we are on the evidence, but it is noticeable, and I said I'd give you some of the references.
Yes.
It is notable that, for instance, in relation to Dr. B, in supplementary bundle.
Have we got to a point where you could just give us the references rather?
Yeah, it's fine. Yeah.
Conscious of the time.
Yeah.
But don't
C.
Right.
Dr. B, C86, para 17.
Yeah.
And then the reference, he goes on to the pain report, which says it's impossible to know how much she feels.
Yes.
Dr. A, C129 and C154.
Sorry, C.
129 and C154.
Dr. A administered the pain.
Yes.
Or,
But she'd also
the
put
prepared
yes,
report.
yes,
pain report.
yes. And then Dr. Samuels,
Yeah.
C67, para 3, where he uses the word intermittent and quotes unpleasant sensations. And the point to be drawn from this is, if in fact what Mr. Justice MacDonald called consistent pain, and accepting he's entitled to use the word pain, is in fact intermittent, unpleasant sensations, then going back to the thing that he found decisive in 95 and 96,
Yes.
is
Wouldn't have been sufficient to out. We should not have been the decisive
yes,
point.
it's not sufficient to, cannot be sufficient to outweigh all the other factors coming from the core of who this child is, what her values are, what her value system is, the strong presumption to preserve life, which again he's referred to and again directs himself about at paragraph 97 with his reference to the sanctity of life, and that simply nobody on that evidence, or nobody with that evidence of pain, would make the decision.
Okay.
Well, it was wrong to, not nobody.
If you're wrong about that, if we don't accept your description of what he should have found about pain, and if we conclude the judge was entitled to make the finding he did on pain, do you nonetheless say that that was insufficient to outweigh the other factors?
Yes.
So even if you're wrong on that, even if the judge was entitled to make all the findings he did about pain, still wasn't enough.
Yes. Yes. And as a way of testing that, and I accept, of course, the court's caution about comparing apparent like with what may be unlike. If we look at what at some of the passages from Rakib, in which which is tab 25, so that will be bundle 2 of the authorities. I'll wait for the...
No.
This was another best interests case,
yes,
decided by Mr. Justice MacDonald, in which he came, in fact, to a different decision as to whether treatment should be withdrawn from this one. And it's just instructive, and I don't want to take too much time because, of course, different cases are different. But to look at some of the findings that he made in Rakib and comparing those to what he did in the Bixler case.
This is a very... I think you have to be very careful about this. I know you've hedged it all with warnings, but these cases are different.
I do understand. I would like you to look at the prognosis in paragraph 163, which is the internal page 61.
A very long judgment.
It is a very long judgment.
It is a long judgment. Yeah.
So the prognosis that child had compared to the very similar prognosis for Alta, and indeed understanding that...
Well, just a moment. He concluded that she would live for 10 to 20 years if she continued to receive the treatment.
Yes. Well, but the prognosis...
I don't want to distress the parents, but that isn't, sadly, in this case, the life expectancy is much shorter.
I understand that, but this is why I'm citing it, because it has a relevance to pain. Because actually, if in fact you've got a prognosis of a deteriorating position, which we see in paragraph 163, and the various things that poor Tafida Rakib is on the evidence going to suffer, including drug-resistant epilepsy, scoliosis, which
So
may require...
there's no question that this child could feel pain.
There was yes, but all of this would go on for long. I mean, taking my lord's point, essentially, a very serious and on the face of it, potentially painful future or discomfort future for longer results in an outcome because of the other factors in that case. Now,
He found she didn't. He found it. It was likely she does not perceive.
Yeah, I understand the difference in the that he found that she wasn't. That he found
That's
that it was.
That's key to the point.
Yeah, I understand.
From that point, and then if she didn't suffer pain, then that factor wasn't there at all.
Yeah, that's yeah. I don't want to spend too long on that, but it is nevertheless the same sort of evidence in Rakib as to what was or wasn't painful as we had here. We had what is called flexing. Now I understand there's different issues of brain. I can see.
Paragraph 162, though, Mr. Justice MacDonald says there's no gag reflex, effectively, and no facial grimace to deep pain. Well, both of those factors are present here on the medical.
Yes,
So the evidence about pain was different in that case.
I take my lady's point in relation to the issue of pain. Because there was different cortex activity basically in that case.
Well,
anyway,
not just different cortex activity, different manifestations of sensations of pain. Anyway.
Well,
I don't think it's going to get any stronger.
I'd already called it the Duff point, and I don't wish it to survive. To seek to survive the forensic dismantling
it won't.
My lady.
I'm very confident.
Justice Laing
it's going to get worse for you, Mr.
Yes.
I mean, you're I think for my part, I think I have a clear idea of your case of pain. But my lady has a further question. If you finish with Rakib.
Well, yes, I'll finish with Rakib, and yes, what's my lady's question?
What do you say, if anything, about the second sentence of paragraph 90 of the judgment below and the final sentence of paragraph 91? This really touches on your point that there was no evidence of the nature of the peg. The judge said he couldn't describe exactly the nature of the pain. But he says, in light of the finding that she exhibits movements that would cause her pain if she could experience pain, goes on to find that the experience of pain represents a significant burden to her. Yes. Do you have anything to say about that? And that's repeated effectively again in paragraph 91.
And 92.
Yes, it is. 92. The words significant burden of course relate back to all we've been saying about intermittent and so on. They're a long way different from constant and unremitting pain.
Consistent. Oh, sorry.
So,
yes.
They're a long way different from that, and essentially it comes back to the fact that a significant burden should not have been decisive. Yet that is what, going back to 95 and 96, in effect, it becomes. And 99, he at the beginning of 99, Mr. Justice MacDonald says, in Alta's case, I'm satisfied the fact Alta is in consistent pain acts as a very heavy counterweight to the presumption. In my submission, while that might have been right for a child who didn't have this religion, culture and background, it isn't right or couldn't be right for her, and it comes back to him taking the wrong starting point. By getting the wrong starting point, he's never able properly to apply or balance properly the factors that need to be balanced.
And just to be clear, even if we were against you on your challenge to his finding on pain, you say that nonetheless his decision can't stand because of the way he treated it in comparison with the other factors.
Yes, on his own findings, pain couldn't be, and how he expressed the pain, that couldn't be what turns out to be the decisive factor. And just by way of putting a small...
Turning it on its head, do you say then the who alter is point is the decisive factor, or do you say that it's wrong to look at it in terms of single decisive factors? It's a more holistic exercise overall.
I would say that if who is alter is fundamental to taking the right starting point, and then once one has the right starting point, the weight to be given to the other factors falls into place, and pain, if you have the right starting point and the other factors fall into place, pain can never become the decisive factor unless it had been completely intolerable and consistent. And I use the word intolerable because although Mr. Justice Holman deliberately didn't use that word in MB, which is in the bundle of authorities, it is, in my submission, an indicator of the sorts of things that we're talking about. That consistent pain that is, as we know, derived from the shows of discomfort on handling and so on, is a long way away from intolerable pain. And while I can't say that it would have to be intolerable pain, in my submission it's legitimate and appropriate to say it would have to be something close to that before that factor, in this case, could have the significance that it had.
Thank you.
Can I just box off 2 points very briefly? We say, I think I've already addressed the problems with the judge's approach to dying in this country as opposed to dying in Israel. We've looked at paragraph 111, it's also referred to in paragraph 101. You know that you've heard all the material on Jewish law and tradition and so on. It's also, of course, important that Alta's wider family is in Israel. It would not be possible, for instance, for them to sit Shiva or to sit around the person who's died. What if she's in this country? So they couldn't practically do that. And essentially, if she dies in this country, she is put in the position of either breaching the Torah by her not being buried promptly and in any event within 24 hours because she goes to Israel, or she essentially loses the possibility of going to Israel. And the right to have a proper burial, not only is that discussed in the Adath Yisrael case that we've looked at, but it is also part of Article 8. And there is an article that we put in the bundle of authorities at tab 28, which refers to a case Girard and France, which I thought we really would be trespassing on the court's patience if we put in an authority that's only in French, as it is. But essentially, the point is that the right to have a proper burial and so on is an interest protected by Article 8, and the problems for this judgment are that it's not just about life, but it's also about what will happen to Alta if, as the judge has decided, she dies in the intensive care unit in the hospital that she's in. It was viable. I've not touched upon it. You've given me permission to rely on the evidence de bene esse. Of course, the other point to make on pain and on the Israeli customary law point is that there is now, in the evidence that you may permit to be admitted into this appeal, evidence that the judge's approach to pain wasn't right or should be re-looked at, and you've obviously got that point. I'm not going to develop it at any length at all. But when in fact pain turns out to be the critical factor, the fact that in addition to the evidence that was before the judge, and understand all the problems about there not being a transcript or exactly what the oral evidence disclosed, that also has to be set against the fact that there is evidence that evidence might not have been right, and that the judge might have reached a different view. So in those circumstances, to say that pain ends up being the thing that results in the withdrawal of treatment and the decision that this child should die in this country is something about which the court should be particularly circumspect. I just turn my back on the court.
Well, what I was proposing to do is, we've had a long morning, Mr. Siblit. I was proposing to, if you had now reached probably the conclusion of your submissions, to rise now and give you a chance to talk to your clients.
Yes.
If there's anything you want to add, not encouraging you to.
No,
I know in a case like this there will inevitably be points that they'd want to discuss with you.
yes.
So that will give you that chance now. We'll give ourselves an extra 5 minutes. And then now, Miss Mulholland and Miss Holloran, how long do you anticipate you will be?
Not as long as my friend has been in submissions, but there are points, particularly in relation to pain,
Yes.
which I would seek to address
Yes. Well,
your lordship and your ladyships on, and in relation to the submission which was prepared last night. In terms of his skeleton argument, we have both replied to
yes.
that
Well, both.
extensively.
The quality of the skeleton arguments in this case was noticeably high on all sides.
Great.
So we're extremely helpful. So it sounds as though you are confident. I'm leading you now into
Yes,
saying
in fairness, my lord, I didn't give an answer to the question, and I ought to have done. I would anticipate that I will be no longer than an hour,
Yes.
and I may be shorter.
And I think, Miss Holler, I expect you will be less than that.
My lord, mopping up, I would expect.
Okay, all right. Well, I think in those circumstances, we can now allow ourselves what's reduced to 3 minutes. So, and we'll rise now, and we'll resume at 2 o'clock.
All right.
Thank you very much.
I'm now in the live streaming, but as I said, it will broadcast for 90 seconds with a delay.